Good morning. Thank you for joining our live webinar. Today's topic, how do I engage with my lawyer in formulating a legal strategy? I'm using the word lawyer as a generic term. It could be an attorney, an advocate, a paralegal, a legal advisor, depending upon the circumstances and who is advising you. Nonetheless, the topic deals with that issue. How do I engage with my lawyer? To give you a silly example, does it mean that I employ a lawyer, automatically the lawyer will know exactly what to do for me, understand my circumstances, and automatically be able to provide me with the best possible results? Or do I need to inform my lawyer, my legal representative, about certain facts, engage with him or her in order for him to understand your case and to strategize a route or a destination that will serve you best? I hope that makes sense. In other words, do we just go to the lawyer's office, knock on his door, and stipulate I have a legal problem? The father of my child does not want me to have contact. I'm the biological mother. Lawyer says, thank you, pay me a deposit, I'll see what I can do. The lawyer sends the other party a letter, the other party does not agree to it, and takes the matter to court. He follows his own strategy, what he or she believes would be the best under the circumstances. Or is there a requirement that the parties engage with each other? Which is very important. When I say engage with each other, I mean that there's input from the client himself or herself as well. In any legal case, in any legal matter, there are most probably 10 different options available, 10 different avenues that you can follow, or maybe more, maybe much more. I'm just trying to give an example here. One avenue could be, let's try to mediate first. However, mediation might have certain challenges in the sense of it might delay the case longer, it might affect the urgency of the matter, it might fall to the advantage of the other party because the other party can play the mediation process, and that might not be a good strategy under these circumstances. The other strategy could be where the attorneys can communicate with each other, write letters with to each other. That can take place for months and months if that's part of your strategy. If you do not have the energy at present to litigate it, but you want to maybe buy you some time and blame it on the lawyers for not resolving this matter, then that could be your strategy. Or is your strategy going to court immediately and bypassing the potential of mediating, settling this matter via your legal representatives? If that is your strategy and it's workable and you will get the best result which you require under those circumstances, then obviously you should follow that strategy. The theme of today's discussion is whether or not your input is required when dealing with this issue, your strategy. Should your attorney engage with you, your advocate engage with you? Should there be discussions? Should you form part of that think tank, of that discussion table, that strategy table? Should you be in that war room whereby you guys are now unpacking this case, finding out exactly how are we going to deal with this matter? We presume the other party's strategy is delay. For argument's sake, let us say the mother has primary care and the father saw the minor children every second weekend, and all of a sudden the mother halts contact. You cannot have contact anymore. And then she mentions things, for example, like the father, he neglects the children. When the children are in his care, they are actually cared for by his girlfriend. He's not there all the time, etc. And that's her reason for now limiting contact. And she only advises that the father can have contact if contact is supervised. That's her strategy, and that's her way of limiting contact. And her ultimate strategy, her ultimate goal is to let the father have as little contact as possible. So when he ultimately lawyers up and goes to court, the court will say, this is unfortunate, but the reality of the matter is the father last had overnight contact with the minor children a year ago, because her strategy and the father's lawyer strategy was first to resolve this matter via correspondence and maybe to mediate this matter, but that took extremely long to resolve, and it could not have been resolved. It did not resolve. And then the father finally, a year later, took the matter to court. Once he appeared in court and the court heard arguments, the court said, I feel sorry that this was the facts of the matter, the situation, but the reality is the kids never overnighted with you for the last year. We need to now phase in contact. Strategy. However, if the father followed a strategy, understanding what the mother's plan of action is, to delay matters in order to frustrate the father's contact rights, it might have been better for him to urgently approach the court and advise the court. I used to exercise contact to the minor kids every second weekend. The mother stopped contact last weekend. Her reason is because of X, Y, and Z. These are the reasons why I disagree with the mother's contention. Yes, my girlfriend looked after him for half an hour, but obviously I had to go somewhere to buy some food and it was raining and the kids were looked after by her. They know the girlfriend very well. And the same way when the kids are cared for by the mother, she has a boyfriend and the boyfriend also looked after them. Judge, the minor children were in my care every second weekend. That's being frustrated. That's being limited by the mother. The status quo will have to be reverted back to. We should go back to the every second weekend structure. It will not be uprooting the minor children because they only did not exercise every second weekend contact with me for one weekend. That's fine. That's normal. A new routine hasn't necessarily been implemented. And the judge will say, okay, fine. If those are the facts, the mother doesn't dispute that. Minor kids go back to the father, and let us continue with this every second weekend contact arrangement strategy in place. So I have 3 questions. I'll deal with it quickly and we can end this webinar. How important is it to have a legal strategy in a child custody matter? It is extremely important. You need to have it. You need to know what are you asking for, where are you going to, because time is of the essence. Things change. Children get older. Dynamic changes so fast. And you need to know where you're going to. Is a strategy to apply for primary care over the minor children and in the interim to have 50-50 contact or reasonable contact every second weekend? What is your plan? You need to have it and you need to pursue it. It is extremely important. Is a strategy to delay matters? If you are the other side and you are the one that has the upper hand, you need to have a strategy. The next question. I do not know what my lawyer's plan is in my case. Would it be improper for me to ask him what is his strategy if indeed he has one? You need to ask him what is his strategy. You need to sit down with the lawyer and ask, what is our plan of action? Where are we going to with this? Show me the roadmap. And show me this roadmap based upon the fact that there might be a storm, there might be an accident here, there might be a problem here. Let's say the mother does this or the father does that. What is our plan of action? What are we going to do about these circumstances? What do we do if the family advocate's report is not in our favor? What do we do if the social worker's report is not in our favor? What do we do if this matter takes a year or 2? You need to have a strategy, and a lawyer needs to. My apologies, a lawyer needs to have a strategy. And it is important for you to engage with a lawyer and find out if he has a strategy or not. The last question. How actively involved should I be in my case? Do I forward my legal representative with ideas that I may have, or do I wait for him to ask me? You must be extremely active in your case. In the sense of, you are paying this lawyer, this attorney, this advocate to fight your case for you. You need to be involved. You need to be actively involved. If the lawyer is doing a good job and you feel he's doing his job very well, perfectly fine, wonderful. But if he's not doing his job, you need to advise him thereof, at least understand where they're coming from. And if you're not happy and the strategy doesn't look so good and it's going nowhere with this case, you need to address your lawyer on that specific aspect. I hope I done some justice on the specific topic. Please be actively involved in your case, have a strategy, know where your case is going to, and fight for your rights. Thank you very much and have a lovely day.